Good day! Can two people who cannot legally marry still co-own property? Same-sex marriage hindi pa rin legal dito sa Pilipinas. Ating alamin, pag-usapan at aralin natin. In the 2025 Supreme Court case of Josef versus Ursua, GR number 267469, promulgated in February 2025, the court answered this question and clarified the rules on co-ownership in same-sex relationships. Under the Family Code of the Philippines, marriage is defined as a union between a man and a woman. As such, same-sex couples cannot legally marry, and their property relations are not governed by the rules on absolute community or conjugal partnership. Instead, the Supreme Court ruled that Article 148 of the Family Code applies because the parties are legally incapacitated to marry each other, not merely because they chose not to marry. This distinction is crucial in determining the applicable property regime. Under Article 148, when parties who cannot legally marry each other acquire property, only those obtained through their actual joint contributions, whether in money, property, or industry, shall be co-owned and strictly in proportion to such contributions. The court emphasized that co-ownership does not arise from cohabitation alone, and unlike in Article 147, indirect contributions such as care or household services are not automatically recognized. Ito ang pinagkaiba from Article 147. Dapat may resibo ang contribution. In this case, petitioner Jennifer, Josef, and respondent Evelyn Ursua were in a same-sex relationship and acquired real property during their cohabitation. However, the property was registered solely in Ursua's name. Subsequently, Ursua executed an acknowledgement of third-party claim, expressly stating that Joseph contributed to the acquisition and improvement of the property and was entitled to 50% of its value. When the relationship ended, Joseph filed an action for partition. Both the Regional Trial Court and the Court of Appeals ruled against Joseph, holding that she failed to sufficiently prove her contribution. However, the Supreme Court reversed these rulings. First, the court held that the acknowledgement of third-party claim constitutes prima facie evidence of co-ownership. As an extrajudicial admission against interest, it carries significant evidentiary weight and may even dispense with the need for further independent proof unless rebutted. Second, the court applied the principle of contra proferentem, which states that any ambiguity in a document must be construed against the party who drafted it. Since Ursua executed the acknowledgement, any vagueness in its terms was interpreted against her. Third, while Article 148 requires proof of actual contribution, the court ruled that the acknowledgement itself serves as sufficient initial proof. Consequently, the burden of proof shifted to Ursua to disprove Joseph's contribution. The court found that Ursua failed to overcome this presumption. Moreover, since there was no clear evidence establishing the exact proportion of their contributions, the court applied the rule that co-owners are presumed to have equal shares when contribution is proven but not quantified. Finally, the court emphasized that once co-ownership is established, any co-owner has the right to demand partition as a matter of right, and no one can be compelled to remain in the co-ownership. In sum, the case of Josef versus Ursua, GR number 267469, February 2025, is significant because it affirms that even in same-sex relationships, where marriage is not legally recognized, property rights may still arise through co-ownership. provided there is proof of actual contribution. It also highlights the interplay of family law, property law, and evidence law in resolving modern legal disputes. For any additional discussion, information, or question regarding this topic, please feel free to comment down below. Maraming salamat sa iyong panonood, naway makatulong sa bar. Hanggang sa muli, ito ang iyong review buddy, ang iyong study serye nagsasabing kita-kits sa oath taking. Bye!